Good evening. It is time for today's Tax Talk. I'm your host. I'm attorney Stephen Leahy. Going to get a little bit off today before I go get out any further. Today is Monday, April 11th, the year of our Lord 2022. 1 week before tax day, April 18th, next Monday. So get your taxes done or ask for an extension, but do it right away. Remember, if you have your 2018 tax returns unfiled and you have a refund, you're not going to get that refund if you don't get it in by April 18th, unless you ask for an extension. There's always it depends in the law. Today, I'm not going to talk about the law too much. I help people with foreclosures and other things, and I'm a big advocate of the Constitution. So that's what we're going to talk a little bit about today, the foreclosure moratorium and the Constitution. What does that have to do with one another? Well, let's find out. Won't you join us? Okay, so as I mentioned, we all know about the foreclosure moratorium during the pandemic. There was strict rules on who can actually almost no one could bring a foreclosure case against people. So many landlords were stuck with people not paying their rent, and they couldn't remove them for a long time. And it was always that question in my mind whether this should be a taking. Was the government taking something of value away from its citizens? Unconstitutional? Was this an unconstitutional taking? The Constitution provides, these types of protections, private property. Does that matter anymore? I think a lot during the pandemic, we kind of tossed our constitutional rights. We dug a hole and put them in and pretended like we didn't have them anymore. And it's my contention, always been my contention, always will be my contention, that the Constitution becomes more important when these emergencies happen, not less. We don't give up all of our freedoms forever because a new disease arises. If it is new, this was COVID-19, but there was other strains of COVID. There's been other flus and viruses and other things that have affected many Americans, killed many, unfortunately. But does that mean that we give up our constitutional rights? Well, one of these things was that foreclosure moratorium. The stay-at-home order is another. The mask mandate's another. These are all questions that should be answered in a court of law, in my opinion. Much of this was done by executive order, as was the case here. So let's get to the case. I generally don't like to talk too much about. I'd rather talk about the news than legal jargon, but today it's a little bit different in that there is this case out there that really I think matters, and so that's what we're going to talk a little bit about. So I have this. Let me see if I can get this up. There it is. So the Eighth Circuit rules eviction moratoriums are likely to be takings requiring compensation under the Fifth Amendment. Kind of in a position that I took from the beginning. If the government wants to do these things to protect its citizens, well, they have to compensate the owners of that property, and this is something that wasn't considered. And so here's in the Eighth Circuit. I can tell you about the case, but let's read this story, and then it's got a lot of information. Again, it's a little bit more legal than I like to do for this show, but I think it's appropriate here. The court based its decision on the United States Supreme Court's another decision in Cedar Point Nursery versus Hassed. But on April 5th, In Heights Apartments v. Waltz, a unanimous panel of U.S. Court of Appeals for the Eighth Circuit ruled that the Minnesota state eviction moratorium, enacted for the purpose of mitigating the COVID pandemic, likely qualifies as a taking of private property, requiring compensation under the Takings Clause of the Fifth Amendment. As I think most listeners of the show know that I'm a big advocate of the Constitution, and again, I think we should uphold the Constitution. And I know that a lot of people say that, but in my opinion, a lot of their proposed laws violate the Constitution and should be stricken down. Like this one, in my opinion, likely qualifies as taking. They base their ruling in a large part on the Supreme Court June 2021 decision in Cedar Point Nursery, which held that the temporary physical occupations of property qualify as per se takings that automatically require compensation. Before Cedar Point, conventional wisdom assumed that most temporary physical occupations are subject to the complicated Penn Central balancing test, under which the government usually prevails. I'm not that familiar with this, but I'm not going to get into that test. Here is the key passage from the Eighth Circuit ruling. Now, again, I always recommend that people read some of these opinions. Again, they can get very legalistic, but I think it's important that we all understand what the courts are saying and whether we can agree with them or not. They're not always right, obviously. We're all bound by them, obviously, whether they're right or wrong. And that's why we should hold their feet to the fire and make sure that their reasoning is concrete. Heights alleges that the executive orders effectuated physical takings because they forced landlords to accept the physical occupation of their property, regardless of whether tenants provided compensation. The Waltz defendants contended that no physical takings has occurred because landlords were not deprived of their right to evict a tenant. Rather, they argue, the governor's executive orders imposed only a restriction on when a landlord could evict a tenant, making it similar to the Yee v. City of Escondido, finding a rent control ordinance was not a physical taking. Since the parties briefed this issue, the Supreme Court decided Cedar Point Nursery, which is instructive in this case. So they argued this case, and then the court came out with another case, this Cedar Point Nursery. And it does change, depending on how they come back on that case, how I would argue this new case. In Cedar Point Nursery, the Supreme Court determined a California regulation requiring agricultural employers to permit union organizers onto their property for up to 3 hours per day, 120 days per year, was a per se physical taking under the 5th and 14th Amendments. The court explained, whenever a regulation results in a physical appropriation of property, a per se taking has occurred. It is immaterial whether the physical invasion is permanent or temporary, intermittent as opposed to continuous, or whether the government is directly invading the land or allowing a third party to do so. Cedar Point Nursery controls here, and Yee, which the Waltz defendants rely on, is distinguishable. The rent controls in Yee limited the amount of rent that could be charged, and neither deprived landlords of their rights to evict nor compelled landlords to continue leasing the property past the lease's termination. The landlords in Yee sought to exclude future or incoming tenants rather than existing tenants. Here, the executive order forbade the non-renewal and termination of ongoing leases, even after it had been materially violated, unless the tenants seriously endangered the safety of others or damaged property significantly. According to Heights' complaint, the EOs, turned every lease in Minnesota into an indefinite lease, terminable only at the option of the tenant. Heights has sufficiently alleged that the Waltz defendants deprived Heights of its right to exclude existing tenants without compensation. The well-pleaded allegations are sufficient to give rise to plausible per se physical takings claim under Cedar Point Nursery. I think the Eighth Circuit is right about this. The reasoning of Cedar Point readily applies to eviction moratorium. I reached much of the same conclusion myself. This is the writer talking, not me. In a July 21st, 21 post analyzing a takings claim filed against the now defunct federal eviction moratorium enacted by the Centers for Disease Control and later invalidated by the Supreme Court on grounds unrelated to takings. The takings case against the federal eviction moratorium continues, as affected landlords are, if they prevail, still entitled to compensation for the time during which the moratorium was in effect. Technically, the Eighth Circuit ruling isn't a final decision on the merits. It's merely reverses the trial court's decision to dismiss the case and remands for further proceedings. However, the appellate panel made clear that they think the per se physical takings claim is likely to prevail. Again, what happened is the court dismissed the case, and this court, the appellate court, didn't say that they were wrong. They merely said that they have to reinstate the case and then hear it on its merits. And they voiced their opinion in this case that they think that it will prevail. And so the district court and the trial court has to take that in consideration when they're making a decision. The Eighth Circuit also reversed the trial court's dismissal of the plaintiff's claims for eviction moratorium violated the contracts clause of the Constitution, and that the moratorium might qualify as a taking even under the Penn Central test. That was the test before this new case, right? And it was more strict. So they're saying even under that more strict version, that they think that this would still be a taking. By contrast, they upheld the dismissal of the claim under the petition clause of the First Amendment. I will leave the contracts clause and First Amendment issues to experts in the relevant fields. As for the Penn Central claim, I am skeptical that it can ultimately succeed, though the test is admittedly murky. The Eighth Circuit is also more equivocal about the issue than the per se taking argument. They merely concluded that it is plausible enough to survive a motion to dismiss. But the Penn Central argument won't matter if the courts ultimately conclude that the eviction moratorium was a per se taking under Cedar Point. The Eighth Circuit ruling does not address the argument that an eviction moratorium intended to mitigate the spread of COVID might fall under the police power exception to taking liability. This issue might well come up as the case continues. I am skeptical that the court will or should push the police power exception so far, but the boundaries of that exception are admittedly murky. The three judges of the Eighth Circuit panel are all Republican appointees. It is possible that the more liberal judges would have adopted a narrower interpretation of Cedar Point that would exclude eviction moratoria. But I think it would be difficult to do that in the way that it is coherent. An eviction moratorium is pretty obviously a temporary occupation of property, as it requires the owner to accept the presence of a tenant whom he or she would otherwise have the right to remove. It thereby goes against the owner's right to exclude, which was the central right at issue in Cedar Point. As Chief Justice John Roberts emphasized in his opinion for the court, the right to exclude is universally held to be a fundamental element of a property right. Property rights are what they call a bundle of rights, right? You don't just have the right to possess. You have the right to, as Judge Roberts pointed out, exclude. And you get and you got mineral rights and air rights and all these other rights that go along with property rights, not just the right to possess. I would add also that Cedar Point's logic can be used to challenge conservative laws and regulations no less than the left-leaning ones, like eviction moratoria. A good example of the former are state laws requiring property owners to allow guns on their land, even if they would prefer to bar them. Thus, liberal judges might have reason to doubt the desirability of adopting a very narrow interpretation of Cedar Point. Even if property owners ultimately prevail in this case and other takings claims against eviction moratoria, it remains to be seen how much compensation they would be getting. Calculating it may not be easy, as there is likely to be considerable case-by-case variation. Nonetheless, there are important cases to follow. They could well set significant precedents constraining future eviction moratoria and other similar regulations. This is again an important case, I think, because we have to. In my opinion, here's another case that's a little bit more newsy than legal. I'm already at 15 minutes, so I'm not going to even get into this case. But I thought it was interesting. If I had time, I was going to read it. But again, I think that what happens is that when we have these emergencies, that we lose rights, and it is important that we realize that this can happen, and that we should put barriers in place to stop them from happening again. In my opinion, again, I'm here in Illinois. Our governor here in Illinois has been ruling on executive order under the Emergency Powers Clause of our state constitution, I think, unrightly. My own opinion. I think that the law clearly says that he has 30 days, and after that he has to get legislative permission. Some of our courts here in Illinois have held, no, he just needs to get permission every 30. He just has to promote it every 30 days and declare it every 30 days. If he doesn't declare it, then it expires. But if he declares it, then we get a new one. I don't think that makes sense, in my opinion, because we do have a legislature. The emergency goes beyond 30 days, should have legislative action. We are a democracy after all, and not a dictatorship. And what happens with these executive orders is that they become dictatorial, and it only rests on one man's opinion. I remember here in Illinois, before several weeks before Thanksgiving, our governor came out and said, well, we might be able to do it before Thanksgiving, lift the mask mandate. He did not. He decided it wasn't right. If he decided it was right, he could have done it. But it's only up to one man. I don't think that that's what we here in America, we don't treasure that. We don't want that. We should not even permit it. And if we do permit it, it should be for the shortest possible time. And the rights of the people should prevail. Freedom should ring. Pretty simple to me. And that's why we have a legislature. And if they don't act, that should not give the executive the right to act by himself in his own right under executive order. Just my opinion. I'm glad to see that the Eighth Circuit almost agreed with me. We'll see. It's going back to the court, and it's probably not going to end there. And this case is going to go on for some time. I got to tell you, there's a lot of these cases that are going to go on for some time because there's more than this case, and so we'll see what all this vaccine mandates and things like this. What kind of power does the government, does Joe Biden's administration have to put in vaccine mandates? Does he have the power to do so? We have differing opinions on that, and this is all going to have to be worked out in court. So I want to thank you so much for joining us today. I'm going to ask you to like and share, subscribe to this channel. We need your help to get the word out. Remember, tax news is really the core of all news, and so we need to get this news out, and we need your help to do it. If you're having IRS problems, you owe the IRS some money. Well, that's not it. If you owe the IRS some money, or if you haven't filed your tax returns in some time, the very first thing you should do, you get a notice from the IRS, you know that you owe the IRS money, or you haven't filed your tax return, the first thing you should do, get a copy of my book, Deal with Your IRS Problems Today. It's free. Go to freeirsbook.com, and get your free copy of Deal with Your IRS Problems Today. So thanks so much for joining us here today. Again, this was a little bit more legalistic. I'm an attorney after all. But I think it's important that we should all understand those that are trying to overtake our Constitution and limit our freedoms. And I think that's what this does. This moratorium limited our freedoms. If you are a landlord, and many people, whether they could pay or not, decided not to pay because they didn't have to and they couldn't get evicted. And that went on for a long time, many months, over a year, almost 2 years, I think, that the moratorium was in place, and you could not evict somebody, whether they ever paid you or not. Now, as a landlord, I still have to pay my mortgage. Who helped me do that? Did the government come in and give me the money to do that? The answer is no. There was some money available for the tenants that would go ultimately to the landlord to help them. But if the tenants, in many instances, if the tenant didn't apply, you couldn't get the money. Or if the tenant couldn't prove that they needed the money. So if they just stopped paying you because they heard of the moratorium and they decided they're not going to pay you. If they couldn't prove to the government that they needed the money because of COVID, well, then they didn't get the money. And so therefore either did the landlord. And so this is in my opinion, it's a travesty. Landowners have rights. Not just renters, but landowners have rights. Landlords have rights. So anyway, that's where we are. So thanks so much for joining us here today. I take the time now to remember now tomorrow is Crypto Tuesday, and where we talk about crypto and all things blockchain. So join us here tomorrow, and until then, have a great evening.